Good day. You are here because standards matter. Excellence is always worth striving for. Wouldn't you agree? That understanding is where we begin. This course concerns itself with authority, how it is granted, how it is exercised, and, just as importantly, where it must stop. Every arrest, every search, every seizure rests upon clearly defined legal standards. When those standards are understood and respected, authority is legitimate. When they are not, authority fails. We therefore begin not with action, but with language. Precision in terminology is the first discipline of a professional peace officer. Chapter 10. Arrest, Search, and Seizure. Unit Goal. To understand the role of the peace officer and the rights of citizens as they relate to arrest. This section establishes the foundational terms by which officer conduct is evaluated in court, in policy, and in public trust. These are not academic distinctions. They determine whether an arrest stands or falls, whether evidence is admitted or excluded, and whether authority is exercised lawfully. Proof beyond a reasonable doubt. We begin with the highest standard known to criminal law. Proof beyond a reasonable doubt is the level of certainty required for a conviction at trial. It is the standard that governs the final determination of guilt. It is intentionally demanding, for it protects against wrongful conviction. It is equally important to understand what this standard does not govern. A peace officer does not operate under the burden of proof beyond a reasonable doubt when making decisions in the field. To require such certainty at the moment of arrest would paralyze lawful enforcement and misunderstand the structure of the justice system. Instead, the law assigns different standards to different stages. Proof beyond a reasonable doubt governs conviction. Probable cause governs arrest and search. Reasonable suspicion governs temporary detention. A professional officer distinguishes these standards instinctively and applies each one only where it belongs. Probable cause. Probable cause is the cornerstone of lawful enforcement. It is neither guesswork nor absolute certainty. It is a reasoned judgment, grounded in facts and supported by reliable information. The law recognizes two distinct forms of probable cause, not out of complication, but out of necessity. The question changes depending on the authority being exercised. Probable cause to arrest. Brinegar versus United States. Probable cause to arrest exists when the facts and circumstances within the officer's knowledge, together with reasonably trustworthy information, would lead a reasonable person to believe that a crime has been committed. The focus here is the person. This standard does not require the officer to know everything. It requires the officer to know enough to justify taking another human being into custody. The facts relied upon must be articulable, observable, and defensible. An arrest supported by probable cause is an exercise of lawful authority. An arrest without it is not a mistake of judgment. It is a violation of rights. Probable cause to search. Carroll v. United States. Probable cause to search exists when the facts and circumstances known to the officer, supported by reasonably trustworthy information, would lead a reasonable person to believe that evidence or contraband will be found in a specific place or on a specific person. Here, the focus shifts to location. The question is no longer who committed the offense, but where the evidence of that offense is likely to be found. This distinction is essential in understanding search warrants and the limited circumstances under which warrantless searches are permitted. The probable cause test. In both contexts, probable cause must be grounded in facts sufficient to warrant a reasonable belief that a suspect has committed, is committing, or is about to commit a crime. Suspicion unsupported by evidence is not enough. The law demands a rational connection between facts and conclusions. Objective facts, not subjective good faith. Beck versus Ohio. The courts have rejected the notion that an officer's good intentions alone can justify an arrest or search. If sincerity were enough, constitutional protections would exist only at the discretion of the police. Therefore, the law requires objective justification. Facts must exist. Those facts must be capable of explanation. Authority must be demonstrable, not assumed. This requirement does not weaken law enforcement. It strengthens it by ensuring legitimacy. Reasonable suspicion. Reasonable suspicion is a lesser standard than probable cause, yet it remains a legal threshold of consequence. It authorizes a temporary detention for the purpose of investigation. Mere suspicion. Mere suspicion is intuition, the sense that something may be amiss. Experience often sharpens this instinct, but instinct alone is not law. Mere suspicion allows observation and awareness. It does not permit restraint of liberty. Courts will not uphold a detention based solely on a hunch, no matter how confident the officer may have felt. Reasonable suspicion. United States versus Socolow. Reasonable suspicion exists when specific, articulable facts, viewed under the totality of the circumstances, support the inference that criminal activity may be occurring. This standard is lower than probable cause, but it is not casual. It requires explanation. It requires reasoning. It requires restraint. A detention based on reasonable suspicion must be temporary, focused, and proportional. When the suspicion is resolved, the detention must conclude. Exception. An exception is a statutory limitation that removes conduct from criminal liability under specific conditions. Its presence matters because it can alter whether an offense has occurred at all. An officer who ignores statutory exceptions risks arresting where no crime exists. Careful reading of the law is not optional. It is professional duty. Reasonable belief. Reasonable belief refers to what an ordinary and prudent person would believe under the same circumstances. It is an objective standard, not a personal one. It appears repeatedly throughout Texas law because it anchors authority to reason rather than impulse. A peace officer is judged not by certainty, but by reasonableness, assessed at the moment the decision is made. You will begin to notice a pattern as these standards take shape. The law does not demand perfection from you, it demands discipline. It does not require certainty. It requires reasoned judgment. Exercised at the moment, authority is applied. These terms are not abstractions. They are the measures by which your actions will be weighed, by courts, by the public, and by your own professional conscience. When they are understood, authority stands calmly and without apology. When they are misunderstood, authority falters, regardless of intention. This is why we begin here. Excellence is never a product of impulse. It is the result of clarity, restraint, and deliberate thought. And as we have already agreed, it is always worth striving for. We have spoken of standards, of reasonableness, of judgment, of restraint. Now we turn to how those standards appear in practice. Every interaction between a peace officer and a citizen falls into one of three classifications. Understanding the difference between them is not optional. It determines whether your conduct is lawful or unlawful, whether authority is exercised properly or exceeded. Let us name them plainly before we examine them more closely. Consensual encounters. Investigatory stops or detentions. Arrests. Each carries its own authority. Each carries its own limits. Consensual encounters. Florida vs. Royer. A consensual encounter is the least intrusive form of police contact. It occurs when a peace officer approaches a person and engages them in conversation without restraining their liberty in any way. Questions may be asked, requests may be made, conversation may proceed. The defining feature of a consensual encounter is freedom. During a consensual encounter, the person is not required to identify themselves, is not required to cooperate, is not required to answer questions, and is free to walk away at any time. So long as that freedom exists, the encounter remains consensual. No suspicion is required because no seizure has occurred. The law views this as conversation, not command. The moment that freedom is removed, even subtly, the encounter ceases to be consensual. Investigatory stops and detentions. Terry versus Ohio. An investigatory stop, also called a detention, begins the moment a person is no longer free to leave. This is a temporary seizure, permitted only for the purpose of investigating possible criminal activity. It is no longer a consensual interaction, and because liberty is restrained, the law requires justification. That justification is reasonable suspicion. Reasonable suspicion exists when specific, articulable facts, viewed together under the totality of the circumstances, suggest that criminal activity may be occurring. A detention must remain temporary, focused on the reason it began, and no more intrusive than necessary. It exists to confirm or dispel suspicion. Once that purpose is satisfied, the authority to detain ends. Continued restraint beyond that point is no longer lawful. A disciplined officer understands that detention is a tool, not a holding pattern. Arrests. United States versus Mendenhall. An arrest is the most significant form of police-citizen interaction. It occurs when a person is taken into custody for the purpose of being charged with a crime. At this stage, liberty is no longer temporarily restrained. It is fully seized. This authority requires probable cause. Probable cause to arrest exists when the facts known to the officer would lead a reasonable person to believe that a crime has been committed, and that the person being arrested committed it. An arrest is not defined by volume, posture, or the presence of handcuffs. It is defined by restraint, authority, and the individual's understanding that they are not free to leave. Courts examine arrests carefully because they represent the fullest exercise of police power. You should now see the structure clearly. Consensual encounters require no suspicion because freedom remains intact. Investigatory detentions require reasonable suspicion because freedom is temporarily restrained. Arrests require probable cause because liberty is fully seized. As authority increases, justification must rise with it. This progression is not merely legal theory. It is the architecture of lawful policing. When you understand it, your conduct becomes measured, confident, and unremarkable in the best possible way. Authority, when exercised correctly, rarely announces itself. It simply proceeds. We have already established when an officer may speak, detain, or arrest. Now we must address something more exacting. At what point does the law say, "This is no longer a detention, this is an arrest"? The answer is not found in handcuffs, tone of voice, or paperwork. It is found in 4 necessary conditions. If even one is missing, the arrest fails. Let us take them carefully, as the law does. Necessary conditions for arrest. An arrest exists only when all 4 of the following conditions are present: intent, authority, actual seizure, understanding. They are not flexible. They are cumulative. Intent. We begin with intent because arrests do not occur by accident. Intent refers to the peace officer's purpose to take a person into the custody of the law. This intent may be expressed plainly, or it may be implied by conduct, but it must exist. An officer who has not formed the intent to arrest is not arresting, no matter how uncomfortable the encounter becomes. This is why the law distinguishes sharply between investigative detention and arrest. A detention may involve restraint, but without the intent to take the person into custody, it remains something less. Intent is the officer's internal decision point, the moment investigation ends and custody begins. Authority. Intent alone is meaningless without authority. Authority means the officer is legally empowered to make the arrest, and that the arrest is supported by probable cause. Without both, authority does not exist. This is what the law means by real authority, not assumed authority, not symbolic authority. Authority grounded in statute and fact. An arrest made without authority is unlawful, regardless of confidence or sincerity. Actual seizure. The third condition is actual seizure. This occurs when the person is taken into custody either by physical force or by submission to the officer's authority. Physical contact is not required. Handcuffs are not required. What matters is restraint, the restriction of liberty. Texas law recognizes this clearly. A person is arrested when they are restrained, or when they submit to authority, knowing restraint is intended. This includes what the law calls constructive custody, where physical confinement is not present, but legal control is. Restraint may be obvious or subtle, but when freedom ends, seizure has occurred. Understanding. Finally, the person being arrested must understand the officer's intent to arrest. This does not require formal words. It does not require the phrase, "You are under arrest." It requires awareness. The person must reasonably understand that they are not free to leave, and the officer intends to take them into custody. Without that understanding, the arrest is incomplete. This is why courts examine the totality of the encounter, words, actions, and circumstances, rather than any single ritual. At this point, it becomes clear why courts analyze arrests so carefully. An arrest is not an announcement. It is a legal condition. And because of that, the law places strict limits on when arrests may be made without a warrant. Warrantless arrest authority. In some circumstances, the law permits arrests without a warrant. In others, it does not. And the distinction matters. Certain conditions apply to any person, peace officer or not. Others apply only to peace officers by virtue of their office. For example, the law recognizes arrest authority when an offense occurs in the presence or view of a magistrate, when an offense occurs in the presence or view of a peace officer, when specific statutory conditions are met that justify immediate action. These authorities are narrow by design. They exist to allow enforcement when delay would defeat justice, not to excuse impatience. Suspicious places and circumstances. The law also requires something more demanding than instinct. When relying on suspicious places or suspicious circumstances to justify an arrest, an officer must be able to articulate specific facts, not conclusions, not impressions, facts. Courts have made this clear. The phrase suspicious place does not grant blanket authority. It demands explanation. This is why articulation matters. If you cannot explain why the place or circumstance was suspicious, the authority collapses. Special arrest authorities and limitations. There are also specific situations where the law speaks with particular clarity. A peace officer may not enter a suspect's home to make a routine felony arrest without a warrant unless exigent circumstances exist. This is not preference. It is constitutional command. Entry into a residence to make an arrest without a warrant. We begin with the home. Even when a peace officer has probable cause to believe a felony has been committed, the law does not grant automatic permission to enter a person's residence to make an arrest. The home is afforded heightened constitutional protection. Absent a warrant, entry into a residence to make an arrest is permitted only under limited circumstances, such as valid consent or exigent circumstances. Exigent circumstances are situations where waiting would be unreasonable. For example, an immediate threat to life, hot pursuit of a fleeing felon, or the imminent destruction of evidence. Probable cause alone authorizes an arrest. It does not authorize entry into a home. Arrest authority across jurisdictions under defined conditions. Ordinarily, a peace officer's authority is confined to a specific jurisdiction. However, Texas law recognizes that criminal activity does not respect jurisdictional boundaries. Under defined conditions, most notably fresh pursuit, a peace officer may continue pursuit and make an arrest outside the officer's usual jurisdiction. The pursuit must be lawful at its beginning and continuous in nature. Once the conditions justifying extended authority end, so does the authority itself. Jurisdiction may extend. It does not disappear. The requirement to take an arrested person before a magistrate without unnecessary delay. Once an arrest has been made, the law immediately shifts from enforcement to oversight. Texas law requires that an arrested person be taken before a magistrate without unnecessary delay. This requirement applies to both misdemeanors and felonies. The purpose is judicial review, advisement of rights, and consideration of bail. The law also establishes an outer limit. An arrested person must be taken before a magistrate no later than 48 hours after the arrest. This requirement is not administrative. It is a constitutional safeguard. Warrantless arrests, jail detention, and mandatory release deadlines. At the same time, Texas law provides an additional protection that applies only in specific circumstances. When a person is arrested without a warrant and detained in jail, and a magistrate has not yet determined probable cause, that the law imposes strict release deadlines. For a misdemeanor, if probable cause has not been determined, the person must be released on bond not later than 24 hours after arrest. For a felony, if probable cause has not been determined, the person must be released on bond not later than 48 hours after arrest. The law also limits the bond amounts in these situations. For a misdemeanor, the bond may not exceed $5,000. For a felony, the bond may not exceed $10,000. If the person cannot obtain a surety bond or deposit the required amount, release must be granted on a personal bond. The statute allows a narrow exception. The state may request a delay, but even then the release may not be postponed beyond 72 hours after arrest. These deadlines exist to prevent unlawful detention. When they are missed, release is no longer discretionary. Mandatory arrest, when a protective order is violated in the officer's presence. Most arrest decisions allow discretion. This one does not. When a peace officer personally observes a violation of a protective order, the law requires arrest. The officer does not issue a warning. The officer does not delay. The officer arrests. This mandate exists because protective orders are designed to prevent harm, and hesitation in these situations can lead to escalation. Here, the law speaks plainly. Authority to prevent the consequences of theft. Texas law also recognizes that delay can defeat justice. When there are reasonable grounds to believe that theft has occurred, a peace officer may act immediately to prevent its consequences. This includes seizing stolen property and making an arrest without a warrant when necessary to prevent loss or escape. This authority exists to stop theft while it is unfolding, not merely to document it after the fact. Authority to arrest fugitives from other states under extradition law. Texas has adopted the Uniform Criminal Extradition Act, which governs how the state handles individuals charged with crimes in other states. Under this law, a peace officer may arrest a person without a Texas warrant when there is reliable information that the person is charged in another state with a qualifying offense, typically one punishable by death or imprisonment for more than 1 year. The arrest is not punishment. It is lawful custody pending the extradition process. Diplomatic immunity for certain foreign officials. Diplomatic immunity does not apply to all foreign nationals. It applies only to specific categories of accredited foreign officials recognized under international and federal law. The distinction is deliberate and it must be understood precisely. In general, diplomatic agents, such as certain embassy officials, possess broad immunity from criminal arrest and prosecution, unless that immunity is formally waived by the sending nation. Consular officers possess more limited protections, and arrest authority depends on the nature of the offense and the officer's official status. That said, diplomatic immunity does not place an individual beyond the reach of immediate law enforcement action when public safety is at risk. A diplomatic agent may be arrested for limited purposes when necessary to preserve public order and safety. Such action is permitted in circumstances involving disturbing the peace, preventing imminent violence or harm to others, stopping conduct that poses an immediate threat to public safety. In these situations, the officer's authority is exercised solely to restore order and prevent harm. It is not punishment, and it does not extend to criminal prosecution or custodial detention beyond what is necessary to address the immediate threat. Once the situation is stabilized, the individual is released, and the matter is referred through appropriate diplomatic and federal channels. When diplomatic immunity is claimed, peace officers must verify the individual's status through proper channels. Public safety remains paramount, but criminal enforcement authority may be restricted by law. Here, restraint is not hesitation. It is lawful compliance, legislative privilege for members of the legislature under defined conditions. Texas law also recognizes legislative privilege. Members of the Texas legislature are privileged from arrest during a legislative session and, while traveling to and returning from the session, with travel time calculated at 1 day for every 20 miles of distance from where the legislature convenes. This privilege is not absolute. It does not apply in cases of treason, felony offenses, or breach of the peace. The purpose of this privilege is structural, to protect the functioning of government, not personal immunity from accountability. Now we turn to probable cause and arrest without a warrant. This subject is not about confidence in the moment. It is about judgment that survives scrutiny later. The street is where decisions are made. The court is where those decisions are measured. Let us proceed carefully. Probable cause and arrest without a warrant. An officer may arrest for an offense when probable cause leads the officer to believe that the offense is occurring or has already occurred. That statement is simple, and it is deliberately so. The complexity does not lie in the definition. It lies in the application. Probable cause is not proof beyond a reasonable doubt. It is not certainty. It is a reasonable belief grounded in facts and circumstances that a specific crime has been committed and that a specific person committed it. When that belief exists, the law permits action, including arrest without a warrant when authorized by statute. Whether probable cause actually existed is not decided on the street. That question belongs to the courts. The officer's task is not to win the argument in advance, but to act lawfully based on what is known at the time. That timing matters. The totality of the circumstances. When courts examine an arrest or detention, they do not isolate facts. They examine the totality of the circumstances surrounding the seizure. This means the court looks at the whole picture, what the officer observed, what the officer knew, and how those facts reasonably fit together. Importantly, the court considers only the information known to the officer at the moment of the seizure or search. Evidence discovered later, after the arrest or during a search, cannot be used to retroactively justify probable cause. In other words, the arrest must stand on what justified it at the time it occurred, not on what was found afterward. This principle protects both sides. It prevents hindsight from condemning reasonable decisions, and it prevents unlawful actions from being excused by lucky discoveries. Probable cause as a practical judgment. The courts have been clear about something else, and it is worth remembering. Probable cause is a practical, non-technical concept. It does not demand legal precision or perfect articulation in the moment. It demands reasonable judgment based on real-world experience. In dealing with probable cause, officers deal in probabilities, not certainties. The law expects peace officers to act as reasonable and prudent people would act under similar circumstances, applying training and experience to the facts before them. This is why probable cause is not measured by legal theory, but by practical reasoning. The law does not require officers to think like attorneys. It requires them to think like disciplined professionals. Arrest without a warrant. An arrest without a warrant is lawful only when the law permits it and when probable cause exists. Texas law provides specific authority for warrantless arrests under defined circumstances, such as offenses committed in an officer's presence or other statutorily authorized situations. The presence of probable cause does not grant unlimited power. It must align with lawful arrest authority. When both are present, the arrest stands. When either is missing, it does not. This is why officers must always know what they believe, why they believe it, and what law authorizes action at that moment. The officer's role and the court's role. There is a final distinction that must be understood. The officer's role is to make a decision based on facts and reasonable belief at the time of action. The court's role is to review that decision later, calmly and deliberately, with the benefit of distance. That review is not an insult to authority. It is the structure that gives authority legitimacy. An officer who understands this does not fear review. The officer expects it. The essential lesson. Probable cause is not validated by certainty. It is validated by reason. An arrest without a warrant is not justified by confidence. It is justified by facts, circumstances, and lawful authority. When those elements are present, action is proper. When they are not, restraint is required. That is not hesitation. That is judgment. And judgment, exercised correctly, is the quiet mark of a professional who understands both the reach and the limits of power. That is how probable cause is meant to work. Arrest is not the end of constitutional scrutiny. In many ways, it is where scrutiny sharpens. Once a person is in custody, the law imposes clear limits on how information may be obtained. Those limits govern custodial statements, and they demand careful attention. Custodial statements and the Fifth Amendment. At the foundation of this subject is the Fifth Amendment to the United States Constitution, which protects every person from being compelled to incriminate themselves. That protection applies to citizens and non-citizens alike, and it applies wherever lawful custody exists. For a peace officer, this means one thing above all others. When a person is in custody and subject to interrogation, constitutional safeguards must be honored before questioning begins. Custody refers to a situation where a reasonable person would not feel free to leave. Interrogation refers to questioning or conduct by law enforcement that is reasonably likely to elicit an incriminating response. When both are present, the law requires action. Miranda warnings: when and why. Before any custodial interrogation, peace officers must clearly advise the person of their Miranda rights, as established by Miranda v. Arizona. Those rights include the right to remain silent, the understanding that anything said may be used against them in court, the right to consult with an attorney before questioning and to have that attorney present during questioning, and the right to have an attorney appointed if they cannot afford one. These warnings are not optional, and they are not procedural formalities. They exist to ensure that any statement given is the product of free and informed choice. If Miranda warnings are required and not properly given, the statement does not stand. Language barriers and understanding. A warning that is not understood is not a warning at all. When a person does not speak or understand English, or when the person is deaf or hard of hearing, peace officers must ensure that the Miranda warnings are communicated in a manner the person can understand. This may require the use of a qualified interpreter. The purpose is not translation for its own sake. The purpose is comprehension. A person cannot knowingly and intelligently waive rights they do not understand. Invocation of rights, silence and counsel. Once a person is in custody, they control the conversation. If a person clearly indicates a desire to remain silent, interrogation must stop. Officers may not attempt to persuade, pressure, or continue questioning once that right is invoked. If a person requests an attorney, interrogation must also cease immediately. Questioning may not resume unless an attorney is present, or unless the lawfully required conditions for reinitiation are met. This is not a temporary pause. It is a command. The 14-day rule after requesting counsel. When a person in custody requests an attorney, the law imposes a significant limitation on future questioning. Interrogation may not resume until an attorney is present or there has been a break in Miranda custody lasting at least 14 days. This rule exists to ensure that the request for counsel is respected in substance, not merely in form. A brief release or a short delay is not enough. The break must be real, meaningful, and complete. Only after such a break may officers initiate questioning again, and only after providing fresh Miranda warnings. Texas law on custodial statements. Texas law adds additional structure. Under Texas Code of Criminal Procedure, Article 38.22, custodial statements are admissible only when strict conditions are met. The law distinguishes between written statements, recorded oral statements, and limited exceptions. In general, the person must receive proper Miranda warnings. The person must knowingly, intelligently, and voluntarily waive those rights, and the statement must be obtained in the manner prescribed by law. Statements obtained in violation of these requirements may not be used against the accused in court. The rule is simple. Constitutional compliance is not assumed. It must be demonstrated. Warrant of arrest. What gives a peace officer lawful authority to arrest someone before that arrest occurs? The answer is simple but precise. An arrest warrant is a written order issued by a magistrate directed to a peace officer or, in limited circumstances, another person specifically named, commanding that the accused be taken into custody and brought before the proper authority to be dealt with according to law. That sentence contains everything the law requires. Let us slow it down. A written order. The law begins with writing because writing creates accountability. A warrant must exist as a physical or electronic document. It cannot be implied. It cannot be assumed. It cannot be recreated from memory after the fact. Writing fixes authority at a moment in time and makes it reviewable. If authority is not written, it is not a warrant. Issued by a magistrate. The authority to order an arrest under warrant belongs to the judicial branch, not to law enforcement. A magistrate is a judicial officer authorized to determine whether probable cause exists. That determination must occur before the arrest is made. This separation is intentional. The person who decides whether custody is justified is not the person who carries it out. The officer enforces, the magistrate authorizes. That distinction protects liberty and strengthens the arrest. Directed to a peace officer or some other person specially named. A warrant is not addressed to anyone who finds it. It is directed to someone with legal authority to execute it. In practice, this is almost always a peace officer. The statute allows other persons to be named only when the law specifically permits it. Authority under a warrant is assigned, not universal. Commanding him to take the body of the accused. This language is old, but its meaning is exact. A warrant is a command, not a suggestion. It orders the officer to take the accused into physical custody. Words alone do not satisfy this command. The warrant authorizes restraint of liberty. Once issued, the warrant does not ask whether arrest should occur. It directs that it occur, and bring him before the proper authority to be dealt with according to law. A warrant does not exist to punish. It exists to begin process. The purpose of the arrest is to bring the accused before the judicial system so that rights can be addressed, bail can be considered, and the case can proceed according to law. An arrest under warrant is incomplete until the person is delivered into lawful judicial oversight. Requisites of warrant. Article 15.02 answers a question every disciplined officer must be able to resolve before acting. Does this document actually give me lawful authority to arrest? Texas law is clear on this point. A warrant does not need elegant formatting, ceremonial language, or perfect grammar. What it needs is substance. If the required substance is present, the warrant stands. If it is not, the authority fails. The statute tells us exactly what must be present, issued in the name of the state of Texas. Every arrest warrant must issue in the name of the state of Texas. This matters because the authority to arrest does not belong to a judge personally, nor to an agency, nor to an officer. It belongs to the state itself. The warrant is the state exercising its power through the judicial branch. If the warrant does not speak in the name of the state, it is not the state commanding arrest. Identification of the person to be arrested. The warrant must identify who is to be arrested. If the person's name is known, the name must be stated. If the name is unknown, the warrant must contain a reasonably definite description of the person. This description must be sufficient to distinguish the accused from others and prevent mistaken identity. The law does not allow vague targets. Authority must be aimed at a particular individual. Statement that the person is accused of an offense. The warrant must state that the person is accused of an offense against the laws of the state of Texas, and it must name the offense. This requirement serves two purposes. First, it confirms that the arrest is grounded in a recognized criminal offense, not a personal grievance or undefined wrongdoing. Second, it informs both the officer and the accused of why custody is being imposed. Arrest authority without an articulated offence is not authority at all. Signature of the magistrate. The warrant must be signed by the magistrate. That signature is not ceremonial. It is the moment authority becomes real. By signing, the magistrate affirms that probable cause has been determined and that the state is justified in restraining liberty. A warrant without a magistrate's signature is a draft, not an order. Identification of the magistrate's office. The warrant must include the office of the magistrate, either directly in the document or attached to the magistrate's signature. This requirement ensures transparency and accountability. It allows anyone reviewing the warrant, officer, court, or citizen, to know who issued it and under what authority. Authority that cannot be traced cannot be trusted. What without regard to form really means. States that a warrant is sufficient without regard to form if these substantial requisites are present. This does not mean anything goes. It means the law values substance over appearance. A warrant may look plain. It may be typed, handwritten, or electronically generated. But if it contains the required elements, state authority, identification of the accused, named offence, magistrate signature, and office, it stands. If any of those elements are missing, no formatting will save it. The officer's responsibility. A disciplined officer does not glance at a warrant and assume validity. The officer verifies. Is it issued in the name of the state? Does it clearly identify the person? Does it name an offence? Is it signed by a magistrate? Is the magistrate's office identified? This is not second-guessing the court. It is respecting the limits of authority. Magistrate may issue warrant or summons. Code of Criminal Procedure, Article 15.03. The law does not permit arrest authority to arise from impulse. It must originate from judgment, exercised lawfully, and, when required, under oath. Article 15.03 explains when a magistrate may exercise that judgment and what form that judgment may take. A magistrate may issue either a warrant of arrest or a summons, but only under circumstances the law expressly allows. First, a magistrate may act in any situation where the magistrate is already authorized by law to order the arrest of an offender verbally. When the law grants that authority orally, it also permits the magistrate to reduce that authority to writing through a warrant or summons. Second, a magistrate may act when a person appears before the magistrate and, under oath, states that another individual has committed an offence against the laws of this state. The oath is essential. It transforms an accusation into sworn information, and sworn information is what allows the magistrate to determine probable cause. Without oath, there is no lawful foundation. Third, a magistrate may act in any case specifically named elsewhere in the Code where the law grants special authority to issue warrants of arrest. In these situations, the magistrate's power does not arise from discretion alone, but from direct statutory instruction. In any case where a warrant of arrest may be issued, the magistrate may instead issue a summons. The summons is identical in form to a warrant, except for one crucial difference. It does not command custody. It orders the defendant to appear before a magistrate at a specific time and place. The summons must be lawfully served. Service may be accomplished by delivering a copy personally to the defendant, by leaving it at the defendant's dwelling or usual place of residence with a person of suitable age and discretion who resides there, or by mailing it to the defendant's last known address. A summons is not a suggestion. It carries legal force. If the defendant fails to appear as ordered, the law requires that a warrant of arrest shall be issued. Appearance was offered as restraint without custody. Refusal restores custody as necessity. For purposes of sworn accusation under this article, the law recognizes modern procedure. A person may appear before the magistrate either in person or through an electronic broadcast system. Physical presence is no longer the only lawful means of presenting sworn information. When an electronic broadcast system is used, the law imposes accountability. A recording of the communication between the person and the magistrate must be made. If the defendant is charged, that recording must be preserved until the defendant is acquitted or until all appeals relating to the offence have been exhausted. Authority exercised remotely must still be reviewable later. Defense counsel is not excluded from this process. Upon payment of reasonable reproduction costs, counsel for the defendant is entitled to obtain a copy of the recording. Transparency is not optional. It is built into the structure. For clarity, the law defines an electronic broadcast system as a two-way electronic communication of both image and sound between the person and the magistrate. This includes secure internet video conferencing. The system must allow the magistrate to see and hear the person, and the person to see and hear the magistrate. Warrant extends to every part of the state. Code of Criminal Procedure, Article 15.06. A lawful arrest warrant issued by a county clerk, district clerk, or magistrate, excluding mayors of incorporated cities or towns, extends throughout the entire state of Texas. Any peace officer to whom the warrant is directed, or who lawfully receives it, is authorized to execute that warrant in any county of this state. The authority of a valid warrant does not end at the county line. It travels with the state's command. Warrant issued by other magistrate. Code of Criminal Procedure, Article 15.07. A warrant of arrest issued by a mayor of an incorporated city or town is limited in geographic reach. By default, it may be executed only within the county in which it was issued. That limitation may be removed in one of two ways. First, if the warrant is endorsed by a judge of a court of record, it may be executed in any county in the state of Texas. Second, if the warrant is endorsed by a magistrate in the county where the accused is found, it may be executed within that county. The endorsement must clearly authorize execution, be dated, and be officially signed by the magistrate making it. The exact wording is not controlling. The meaning is. Without proper endorsement, the warrant does not travel. Authority follows authorization, and no further. How warrant is executed. Code of Criminal Procedure, Article 15.16. When an arrest warrant is executed, the officer must act without unnecessary delay. If the magistrate who issued the warrant, or the magistrate named in the warrant, is in the same county where the arrest occurs, the arrested person must be taken before that magistrate. If the issuing or named magistrate is in another county, the arrested person must, without unnecessary delay, be taken before a magistrate in the county of arrest. The law's priority is prompt judicial oversight. To achieve that priority more efficiently, the law allows flexibility. When permitted by Article 15.17, the officer may take the arrested person before a magistrate in a different county, if doing so provides the required warnings more expeditiously. Custody begins with authority. It must be followed immediately by oversight. Duties of arresting officer and magistrate. Code of Criminal Procedure, Article 15.17. Once an arrest is made, authority immediately gives way to oversight. Article 15.17 governs that transition. Prompt presentation before a magistrate. The arresting officer, or the person having custody, must take the arrested person without unnecessary delay, and no later than 48 hours after arrest, before a magistrate. This presentation normally occurs in the county of arrest, but the law allows the person to be taken before a magistrate in any county if doing so provides the required warnings more expeditiously. The appearance may be in person or by video conference, including secure internet video conferencing. In limited circumstances involving civil commitment facilities, the magistrate may conduct these duties at that facility. Magistrates' mandatory warnings and duties. The magistrate must clearly inform the arrested person of the accusation and any supporting affidavit, the right to retain counsel, the right to remain silent, the right to have counsel present during questioning, the right to terminate any interview at any time, the right to an examining trial, and the right to request appointed counsel, if indigent. The magistrate must also explain how to request appointed counsel and ensure reasonable assistance is provided in completing the required forms. If the person does not understand English or is deaf, the magistrate must ensure the warnings are delivered in a manner consistent with law, including use of a qualified interpreter. The magistrate must further advise that the arrested person is not required to make a statement and that any statement made may be used against them. Appointment of counsel. If the arrested person is indigent and requests counsel, a magistrate authorized to appoint counsel must do so according to law. If not authorized, the magistrate must forward the request to the appropriate appointing authority within 24 hours. Bail determination. After determining whether the person is currently on bail for another offense and whether bail restrictions apply, the magistrate must admit the person to bail if allowed by law. Record-keeping requirements. A record must be made of the warnings given, whether the person was informed of the right to request counsel, whether counsel was requested. That record may be written or electronic and must be preserved until the end of the pre-trial hearing, or 91 days for misdemeanors, 120 days for felonies, whichever occurs first. Defense counsel is entitled to a copy, with costs waived for indigent defendants. Special situations addressed by Article 15.17. If credible information suggests mental illness or intellectual disability, the magistrate must initiate the appropriate statutory procedures. For certain family violence-related offences, the arresting authority must provide information necessary for an emergency protection order. For fine-only misdemeanors, the magistrate may release the accused without bond, ordering appearance at a later arraignment, subject to statutory exclusions. Deaf accused persons must be provided a qualified interpreter. If the arrest was made under fresh pursuit authority and is found unlawful, the magistrate must order release. If lawful, extradition procedures apply. Persons appearing under citation are entitled to the same magistration protections as those arrested. If no probable cause is found, the magistrate must enter written findings within 24 hours. Duty of officer to notify probate court. Code of Criminal Procedure, Article 15.171. The law recognizes that some arrested persons are not legally independent. When a peace officer arrests a ward, meaning a person under a court-ordered guardianship, the officer's duty extends beyond custody. As soon as practicable, and no later than the first working day after the arrest, the officer or person having custody must notify the probate court that has jurisdiction over the ward's guardianship. This requirement exists to ensure judicial oversight remains continuous. Guardianship does not disappear at arrest, and the probate court must be informed so it may fulfill its protective role. This is not optional notification. It is a mandatory safeguard. Arrest for out-of-county offence. Code of Criminal Procedure, Article 15.18. When a person is arrested on a warrant issued by another county, The law focuses on speed, clarity, and proper transfer of authority. The arrested person must be taken without unnecessary delay before a magistrate in the county of arrest. If doing so will provide the required warnings more quickly, the person may instead be taken before a magistrate in any county, including the county that issued the warrant. Once before the magistrate, the law provides two distinct paths. Path 1. Bail and transfer of bond. If the offence allows bail, the magistrate may take bail. If the magistrate does not have jurisdiction over the offence, the bond must be immediately transmitted to the court that does have jurisdiction. Custody is addressed locally. The case belongs to the issuing county. Path 2. Fine-only offences. If the warrant is for an offence punishable by fine only, the magistrate may fully resolve the matter. In these cases, the magistrate may accept a written plea of guilty or nolo contender, set the fine and determine costs, accept payment, credit time, served, determine indigency, and, when satisfied, discharge the defendant. This prevents unnecessary transport and delay for minor offences. Right to counsel when arrest occurs outside issuing county. When the arrested person is taken before a magistrate other than the issuing county's magistrate, that magistrate must explain the procedures for requesting appointed counsel, provide reasonable assistance in completing the request forms. If counsel is requested, the magistrate must transmit the request to the proper appointing authority in the issuing county within 24 hours. Geography does not suspend the right to counsel. Transmission of records for fine-only cases. If a fine-only case is resolved by plea, the magistrate must, before the 11th business day, transmit to the court with jurisdiction the written plea, any orders entered, and any fine or costs collected. Authority may be exercised locally, but records must return to their proper home. Electronic appearance permitted. The arrested person may appear before the magistrate by electronic broadcast system, subject to the same safeguards and requirements applied under Article 15.17. Efficiency is allowed. Oversight is never waived. Notice of arrest. Code of Criminal Procedure, Article 15.19. When an arrested person fails or refuses to give bail under Article 15.18, the law moves immediately to custody management and notification. The person must be committed to the jail of the county where the arrest occurred. At that moment, the magistrate's duty is not complete. The magistrate must immediately notify the sheriff of the county where the offence is alleged to have been committed. That notice must include confirmation of the arrest and commitment, and whether the person was also arrested under a parole-related warrant issued under Section 508.251 of the Government Code. The notice may be delivered by secure written means, including electronic transmission. Speed and certainty are the priority. Temporary confinement outside the arrest county. If the arrested person is taken before a magistrate in a different county and is remanded to custody, the law allows temporary confinement in the magistrate's county. That confinement is strictly limited. The person may be held there for no more than 72 hours after arrest, after which the person must be transferred to the jail of the county where the arrest occurred. Temporary custody is permitted. Indefinite placement is not. Release on personal bond if not timely demanded. Code of Criminal Procedure, Article 15.21. The law does not permit a person to remain in custody because another county failed to act. If the proper office of the county where the offence is alleged to have been committed does not demand the arrested person and take custody before the 11th day after the person is committed to the jail of the arresting county, the law intervenes. At that point, a magistrate in the county of arrest must act. The magistrate shall release the arrested person on a personal bond without sureties or other security, and forward the personal bond to either the sheriff of the county where the offence is alleged to have been committed or the court that issued the warrant of arrest. This is not discretion, it is command. When a person is arrested. Code of Criminal Procedure, Article 15.22. An arrest occurs at the moment liberty is restrained. A person is considered arrested when they are actually placed under restraint or taken into custody by an officer or other authorized person executing a warrant of arrest, or an officer or other authorized person making an arrest without a warrant. Time of arrest. Code of Criminal Procedure, Article 15.23. Texas law places no restriction on the timing of a lawful arrest. An arrest may be made on any day and at any time. Authority to arrest must be made known. Code of Criminal Procedure, Article 15.26. When executing an arrest warrant, authority must be disclosed. The accused must be informed under what authority the arrest is being made. An arrest is accomplished by taking the defendant into custody, not by possession of paperwork. The officer is not required to have the warrant physically in hand at the moment of arrest, provided the warrant was lawfully issued. However, upon request, the officer must show the warrant to the defendant as soon as possible. If the officer does not have the warrant at the time of arrest, the officer must inform the defendant of the offence charged and that a warrant has been issued. Transparency does not end with custody. Once the warrant is executed, the arrest warrant and any supporting affidavit become public information immediately. The magistrate's clerk must make copies available for public inspection during normal business hours. Copies may be provided upon payment of the required cost. Authority here is neither secret nor assumed. It is declared, documented, and open to review. That openness is not a weakness. It is the structure that makes lawful power endure. Notification to schools required. Code of Criminal Procedure, Article 15.27. This article governs information flow after arrest, not punishment. Its purpose is school safety, not discipline. When a law enforcement agency arrests a person or refers a child to juvenile authorities, and the agency knows or believes the individual is a student enrolled in a public or private primary or secondary school, the agency must act. Initial determination and oral notification. The agency must first attempt to determine whether the arrested or referred individual is a student. If the individual is confirmed to be a student, the head of the agency or a designee must orally notify the school superintendent or the superintendent's designee within 24 hours or before the next school day, whichever occurs first. If enrollment cannot be confirmed, oral notification must still be made to the district where the student is believed to be enrolled within the same time frame. If the individual is a student, the superintendent or designee must immediately notify instructional and support personnel who supervise that student. All such information must be kept confidential. Intentional disclosure is grounds for certification discipline. Written follow-up notification. Within 7 days of the oral notice, the law enforcement agency must mail a written notice, clearly marked personal and confidential. That written notice must include the facts provided orally, the identity of the person notified, and the date and time of the oral notice. Both oral and written notifications must contain sufficient detail to allow the school to determine whether the conduct constitutes a felony, whether a threat assessment is required, or whether a safety plan should be prepared. Post-disposition notifications. Upon conviction, deferred adjudication, deferred prosecution, or delinquent adjudication, the prosecuting attorney must orally notify the superintendent within 24 hours or before the next school day, indicate whether the student is required to register as a sex offender. Written notice must follow within 7 days. The superintendent must again notify supervising personnel within 24 hours. Transfers and re-enrollment. If a student transfers schools or is removed and later returns, probation, parole, or juvenile justice authorities must notify the receiving school district within 24 hours or before the next school day. The receiving superintendent or principal must then notify supervising personnel. Search warrant. Code of Criminal Procedure. Article 18.01. A search warrant is the law's most deliberate intrusion. It is authority to enter, to search, and to seize, and it exists only under strict conditions. Article 18.01 defines what a search warrant is, how it is obtained, who may issue it, and what limits bind it. What a search warrant is. A search warrant is a written order issued by a magistrate and directed to a peace officer. It commands the officer to search for specific property or items and seize them, or, in limited cases, search for and photograph a child, and deliver the resulting images to the magistrate. This authority is precise. A search warrant does not authorize exploration. It authorizes exact action. Probable cause is mandatory. No search warrant may issue in Texas unless the magistrate is first satisfied that probable cause actually exists. That determination must be based on a sworn affidavit setting forth substantial facts, not conclusions, not suspicions. Once the warrant is executed, the affidavit becomes public information, and the clerk must make it available for inspection. Search authority does not hide. It stands ready for review. Electronic and telephonic warrants. Modern procedure does not weaken standards. It preserves them. A magistrate may consider information communicated by telephone or other reliable electronic means, but the applicant must be placed under oath. Testimony must be recorded verbatim. Recordings or transcripts must be preserved and certified. Exhibits must be retained. The applicant must prepare a duplicate original warrant, transmit its contents verbatim, and the magistrate must enter or approve the final version. The magistrate must sign the warrant, record the date and time of issuance, and ensure proper transmission. Evidence obtained this way is not subject to suppression merely because electronic procedures were used, absent bad faith. Technology is allowed, carelessness is not. Special probable cause requirements. Article 18.02, a warrants. For warrants seeking evidence not otherwise listed in the traditional categories, the affidavit must establish probable cause, that a specific offence occurred, that the items sought are evidence of that offence or of who committed it, and that the items are located at the specific place or person to be searched. Only certain judges may issue these warrants, and repeat searches require higher judicial authority. The law tightens scrutiny as intrusion increases, limits on what may be seized. Only the items specifically described in the warrant or contraband listed in the statute may be seized. When the search involves news media offices, the law is even stricter. Certain categories of property may never be seized from newspapers, magazines, television stations, or radio stations under these warrants. The First Amendment is not an afterthought. It is built into the warrant process itself. Photographing a person. Article 18.021 warrants. A warrant to photograph a person may issue only when the affidavit establishes probable cause that a specific offense occurred, that a specific person was a victim, that evidence can be captured photographically, and that the person to be photographed is at the specified location. This is evidence gathering, not identification fishing. Contraband warrants. Article 18.02a. Search warrants for contraband require probable cause of a specific felony and probable cause that the items are contraband and located at the described place. Only designated judges may issue these warrants, unless the county lacks such judges. Then limited exceptions apply. Blood specimen warrants in DWI cases. A magistrate who is a licensed attorney may issue a warrant to collect a blood specimen when the person is arrested for specified intoxication offenses and the person refuses breath or blood testing. Sealing of affidavit. Code of Criminal Procedure, Article 18.011. Transparency is the rule in search warrants. Sealing is the exception. Who may request sealing, and from whom? Only an attorney representing the state in the prosecution of felonies may request that a search warrant affidavit be sealed. That request may be made only to a district judge or a judge of an appellate court. This is not a routine request. It is a controlled judicial act, when an affidavit may be sealed. A judge may order an affidavit sealed only if the state establishes a compelling state interest. The law recognizes two such interests: protection and preservation. If public disclosure would jeopardize the safety of a victim, witness, or confidential informant, or risk the destruction of evidence. Active wiretap protection. If the affidavit contains information obtained from a court-ordered wiretap that has not yet expired. Absent one of these conditions, sealing is not permitted. Duration of sealing. A sealing order is temporary. The initial sealing order expires on the 31st day after the search warrant is executed. Before that expiration, the state may request one additional 30-day extension, but only upon a new finding of compelling state interest. No rolling extensions, no indefinite secrecy. Mandatory unsealing. Once the sealing period and any permitted extension expire, the affidavit must be unsealed. Secrecy ends by operation of law. What sealing does not do. A sealing order cannot block disclosure of the search warrant itself, block disclosure of the return of the warrant, block disclosure of the inventory of property seized, or interfere with the defendant's right to discovery of the affidavit. Sealing protects safety and investigations, not accountability. Grounds for issuance. Code of Criminal Procedure. Article 18.02. A search warrant is not open-ended authority. It may be issued only for specific categories of persons or property that the law expressly authorizes. Article 18.02. Grounds for issuance provides that list. If what you seek is not on it, a warrant may not issue. Let us proceed carefully. Property connected to crime. A warrant may be issued to search for and seize property acquired by theft or other criminal means. This includes stolen property or property obtained in any manner that itself constitutes a criminal offense. Property designed or commonly used to commit an offense. This covers tools, devices, or items adapted for criminal use. Not innocent objects, but those tied to unlawful purpose. Implements or instruments used in the commission of a crime. These are the means by which an offense was carried out. Tools, devices, or equipment used to accomplish the criminal act. Weapons and public order. A warrant may be issued for arms and munitions kept for insurrection or riot. This is narrow and serious. Items prepared for organized violence against public order. Weapons prohibited by the Penal Code. If possession of a weapon is illegal under Texas law, it may be seized under warrant. Gambling, obscenity, and controlled substances. A warrant may be issued for gambling devices, equipment, or paraphernalia, including altered gambling equipment designed to evade detection. Obscene materials prepared for commercial distribution or exhibition. This category is subject to additional constitutional and statutory safeguards. The law allows seizure only under strict conditions. Controlled substances and related items. This includes drugs, precursors, chemicals, paraphernalia, and apparatus manufactured or possessed in violation of Texas law. Property prohibited by law. A warrant may be issued for any property the possession of which is prohibited by law. If the law forbids possession outright, the item may be seized. Evidence of an offense. A warrant may be issued for property or items constituting evidence of an offense. This includes items tending to show that a specific offense was committed or that a particular person committed it. The law draws one important boundary here. Personal writings of the accused are excluded, except as otherwise allowed by law. Evidence is allowed, private thought is protected, persons and contraband. A warrant may be issued to search for persons. This includes individuals who are themselves the object of the search, such as fugitives or missing persons under lawful authority. Contraband subject to forfeiture. Contraband is property that was used in committing certain crimes, was intended to be used in committing those crimes, or was acquired with proceeds from those crimes. The focus is the relationship between the property and the offense. Common examples of contraband. Under Chapter 59, contraband commonly includes money gained from or intended for criminal activity, vehicles used to transport drugs, commit felonies, or flee, firearms used in certain criminal offenses, drugs and controlled substances, equipment or tools used to manufacture, distribute, or facilitate crime, property purchased with criminal proceeds. If the property helped the crime happen or exists because the crime happened, it may be contraband. Digital and electronic evidence. Modern law recognizes modern evidence. A warrant may be issued for electronic customer data held in electronic storage, including contents, records, and information related to wire or electronic communications. Cellular telephones and wireless communication devices. These are subject to additional statutory requirements and heightened scrutiny. The statute defines key terms: electronic communication, wire communication, electronic storage, and electronic customer data, by reference to related chapters, ensuring precision in digital searches. Issuance of search warrant to photograph injured child. Code of Criminal Procedure, Article 18.021. This article addresses a narrow and serious form of search authority, one grounded in protection, not intrusion. A search warrant may be issued to locate and photograph a child who is alleged to be the victim of injury to a child, sexual assault of a child, aggravated sexual assault of a child, or continuous sexual abuse of a young child or disabled individual. The purpose of this warrant is documentation of injury, not removal or detention. Execution of the warrant. The officer executing the warrant may be accompanied by a law enforcement employed photographer, acting under the officer's direction. that photographer is entitled to the same access to the child as the officer. The warrant itself must be specific. It must identify the child to be located and photographed as precisely as possible, describe the place or thing to be searched, and command a peace officer of the proper county to locate and photograph the child. Precision here is not formality. It is protection. Handling of the photographs. Once the child is located and photographed, the officer must take possession of the exposed film or images and deliver them immediately to the magistrate. The child may not be removed from the premises under this warrant, except as authorized under the Family Code. This warrant documents harm. It does not create custody. Sex-specific safeguards. The warrant must be executed by a peace officer of the same sex as the alleged victim. If that is not possible, the officer must be assisted by a person of the same sex as the child, acting under the officer's direction and present during the photography. This requirement exists to preserve dignity and minimize further trauma. Search warrant may order arrest. Code of Criminal Procedure Article 18.03. A search warrant may do more than authorize a search. If the facts presented to the magistrate in support of a search warrant also establish probable cause that a person has committed an offense, the magistrate may include in the same instrument an order for that person's arrest. This authority is not automatic. It exists only when probable cause supports both the search and the arrest. Contents of warrant. Code of Criminal Procedure, Article 18.04. A search warrant does not derive its strength from appearance. It derives its strength from required content. A search warrant issued under this chapter, or under Chapters 18A or 18B, is legally sufficient if it contains the following elements. First, it must run in the name of the state of Texas. This makes clear that the authority exercised is the state's authority, not personal, not discretionary. Second, it must identify what is to be seized and name or describe, as precisely as possible, the person, place, or thing to be searched. Authority must be aimed, not general. Third, it must command a peace officer of the proper county to conduct the search forthwith. A warrant authorizes action. It does not invite delay. Fourth, it must be dated and signed by the magistrate. The date fixes the moment authority begins. The signature confirms that judicial judgment has been exercised. Finally, the magistrate's name must appear clearly, either handwritten or typed, alongside the signature. Authority must be identifiable and traceable. Warrants for fire, health, and code inspections. Code of Criminal Procedure Article 18.05. Not every search warrant exists to uncover crime. Some exist to protect life, health, and safety. Article 18.05 authorizes search warrants for regulatory inspections, but only under carefully defined limits. Who may receive this type of warrant? A search warrant may be issued to a fire marshal, a health officer, or a code enforcement official, acting on behalf of the state or a political subdivision for the limited purpose of inspecting specified premises for fire hazards, health hazards, unsafe building conditions, or violations of fire, health, or building laws or ordinances. This is inspection authority, not criminal investigation authority. Probable cause is still required. A warrant under this article may not issue unless the magistrate is presented with evidence of probable cause to believe that a hazard, a violation, or an unsafe condition is present on the premises. Regulatory purpose does not eliminate constitutional safeguards. Execution of warrants. Code of Criminal Procedure, Article 18.06. Once a search warrant is delivered to a peace officer, it must be executed without delay. Authority granted is authority meant to be exercised. After execution, the warrant must be returned to the proper magistrate. Judicial oversight concludes the process. When conducting the search, the officer must present a copy of the warrant to the owner of the premises, if the owner is present. If the owner is not present, but another person is in possession of the premises, the warrant must be presented to that person instead. Before any property is removed, the officer must prepare a written inventory of the items to be seized. The officer must clearly endorse their name on the inventory and provide a copy to the owner or person in possession. If no one is present at the location when the warrant is executed, the officer must leave a copy of the warrant and the inventory at the premises. Authority here is exercised openly, documented carefully, and returned to the court. That transparency is not optional. It is required. Days allowed for warrant to run. Code of Criminal Procedure. Article 18.07. A search warrant does not exist indefinitely. Its authority runs for a defined period, and then it expires. Time limits for execution. Unless the magistrate specifies a shorter period, the time allowed to execute a search warrant, excluding the day it is issued and the day it is executed, is 15 whole days when the warrant is issued solely to seize biological specimens from a specific person for DNA analysis, including blood or saliva. 10 whole days when the warrant is issued for electronic customer data. 3 whole days for all other search warrants. If the warrant is not executed within the allowed time, authority ends, shall seize accused and property. Code of Criminal Procedure Article 18.09. K. A search warrant is not satisfied by discovery alone. It commands action. When the property described in the warrant is found, the officer shall seize it. Possession must be taken, and the property must be carried before the magistrate. Discovery without seizure is incomplete execution. If the warrant also directs the arrest of a person, the officer shall arrest that person and immediately take them before the magistrate. Custody and oversight follow without delay. The law also defines what seizure means. A seizure of property occurs when the officer restrains the property, whether by physical control or by a show of lawful authority. It includes the act of collecting the property or formally taking possession of it. Seizure, then, is not merely touching an item, it is the assertion of lawful control. Seizure of circuit board of gambling device, equipment, or paraphernalia. Code of Criminal Procedure Article 18.095. This article recognizes a practical reality. Sometimes seizing everything is unnecessary to stop unlawful conduct. When a search warrant authorizes the seizure of a gambling device, altered gambling equipment, or gambling paraphernalia, the officer is given discretion. Rather than removing the entire machine, the officer may seize only the programmable main circuit board, but only if that circuit board is a designed subassembly or essential component, and the part that enables the device to operate as an unlawful gambling device. This is not partial enforcement. It is targeted enforcement. How return made? Code of Criminal Procedure Article 18.10. A search warrant does not end when the search is complete. It ends when the court is informed. Article 18.10 governs what must happen after execution, and it exists to ensure that judicial authority remains continuous from issuance to conclusion. Time limit for return. Once a search warrant is executed, the officer must return the warrant no later than 3 whole days after execution. This return is not optional. It is the final act of accountability. What the return must include. When returning the warrant, the officer must state how the warrant was executed, written on the back of the warrant or on an attached document, and deliver to the magistrate a copy of the inventory listing all property seized. This ensures the court knows what authority was exercised and what property was taken under that authority. Failure to timely return. If an officer fails to return the warrant on time or fails to submit the inventory, evidence is not automatically excluded. The law is clear. A procedural delay does not bar admissibility under Article 38.23. However, this does not excuse negligence. It preserves evidence, not indiscipline. Custody and safekeeping of seized property. The officer who seized the property must retain custody of it until the magistrate issues an order directing how the property is to be safeguarded. Until that order is given, the officer holds the property in trust for the court. Removal of property from the county. As a general rule, seized property may not be removed from the county where it was seized without a magistrate's approval from the issuing county. There is one practical exception. Seized items may be sent to a laboratory for scientific analysis without a court order. Evidence may travel for examination, but not for convenience. Special rule for certain warrants. Property seized under Article 18.067 may be transported from the county of seizure back to the county that issued the warrant without a court order, solely for purposes of complying with return requirements. This exception is narrow and procedural. What Article 18.067 is, and why it exists. Article 18.067 is execution of search warrant outside issuing county and deals with where seized property may be physically located after a warrant is executed, when the issuing court and the place of seizure are in different counties. Normally, seized property may not be removed from the county where it was seized without a magistrate's approval. That rule protects jurisdiction and oversight. Article 18.067 creates a limited logistical exception to that rule. What Article 18.067 allows. When a search warrant is issued in one county but executed in another, Article 18.067 allows the officer to transport the seized property back to the county that issued the warrant without first obtaining a separate court order, solely so the warrant may be properly returned to the issuing magistrate as required by law. This authority exists for administrative completion, not investigative convenience. Custody of property found. Code of Criminal Procedure Article 18.11. Pass. Once property is seized under a search warrant, it does not belong to the officer. It belongs to the court. Custody of property found makes this clear. All property seized pursuant to a search warrant must be kept and handled exactly as directed by a magistrate's order, issued under Article 18.10. Until that order is given, custody is temporary. After the order, custody is controlled. The officer's role is not discretion, it is compliance. Testing certain defendants or confined persons for communicable diseases. Code of Criminal Procedure, Article 18.22. This article does not concern punishment. It concerns exposure. Article 18.22, Testing certain defendants or confined persons for communicable diseases, governs what happens when bodily fluids from an arrested or confined person come into contact with another person in the course of duty, creating a potential health risk. The law responds not with accusation, but with controlled medical inquiry. When this article applies. This authority is triggered when a person arrested for a misdemeanor or felony causes their bodily fluids to come into contact with another individual during any of the following stages: during the commission of the offense, during the arrest, during a judicial proceeding, during the initial period of confinement after arrest. or during confinement, following conviction or adjudication. The protected individuals include peace officers, magistrates, correctional facility employees, and emergency response employees or volunteers, as defined by law. This article exists because exposure risk does not end at arrest. Court-ordered medical testing. When qualifying contact occurs, the court with jurisdiction over the arrested person may order the person to undergo a medical procedure or test designed to determine whether the person has a communicable disease. The court may issue this order on its own motion or upon request by the exposed officer, magistrate, correctional employee, or emergency responder. If the person refuses to submit voluntarily, the court must compel compliance. This is judicial authority, not medical discretion. Handling and disclosure of test results. The person conducting the test must provide the results to the local health authority. Depending on who was exposed, notification then flows only to the peace officer, magistrate, or correctional employee involved, or the emergency responder or volunteer exposed, either directly or through the designated infection control officer. No broader disclosure is permitted. Medical privacy is preserved by law. Limits on use of test results. The law draws a firm boundary here. Neither the fact that a test was performed, nor the results of the test may be used by the state in any criminal proceeding arising from the alleged offense. This is not evidence. It is protection. Testing protocols and rights. All testing must be conducted in accordance with written infectious disease control protocols adopted by the Department of State Health Services. These protocols must establish clear criteria for testing and respect the rights of both the arrested person and the exposed individual. Procedure governs compassion here. Confidentiality is absolute. Nothing in this article authorizes release of test results to anyone other than those expressly named. No other statute may be used to widen disclosure. Health information is controlled. Disclosure is limited. Oversight is strict. Definition of bail. Code of Criminal Procedure, Article 17.01. Bail is not punishment. It is assurance. Under Texas law, bail is the security given by the accused to guarantee one thing, and one thing only, that the accused will appear before the proper court and answer the accusation brought against them. That security may take one of two lawful forms, a bail bond or a personal bond. Both serve the same purpose. They exist to secure appearance, not to express guilt, fear, or severity. Bail answers a single question the law always asks after arrest. Can this person be trusted to return when required? Release on bond of certain persons arrested without a warrant. Code of Criminal Procedure, Article 17.033. This article answers a precise question. How long may the state hold a person arrested without a warrant before a magistrate determines probable cause? The law answers with deadlines, and those deadlines have consequences. Warrantless misdemeanor arrests, 24 hours. When a person is arrested without a warrant, detained in jail, and accused of a misdemeanor, the law requires release no later than the 24th hour after arrest, if a magistrate has not yet determined probable cause. The bond amount may not exceed $5,000. If the person cannot secure a surety or cannot deposit the required funds, then the law requires release on a personal bond. This is not discretionary, it is mandatory. Warrantless felony arrests, 48 hours. When a person is arrested without a warrant, detained in jail, and accused of a felony, the deadline extends to 48 hours. If no magistrate has determined probable cause by that time, the person must be released. The bond amount may not exceed $10,000. Again, if the person cannot post that bond, release must be on a personal bond. Judicial silence cannot justify continued detention. Limited delay, up to 72 hours. The law allows one narrow exception. If the attorney representing the state files an application explaining why probable cause has not yet been determined, a magistrate may postpone release. That postponement may not exceed 72 hours after arrest and must be supported by a stated reason. This is a delay, not an avoidance. Medical treatment pauses the clock. The statutory time limits do not run while the arrested person is at a hospital, clinic, or other medical facility prior to being taken before a magistrate. In those cases, the clock begins when the medical provider releases the person, as documented in medical records. The law does not penalize medical necessity, but it does resume oversight immediately after. Rules for setting amount of bail. Code of Criminal Procedure Article 17.15. Bail is not arbitrary. It is governed by the Constitution first, and by structure second. Rules for setting amount of bail instructs the court, the magistrate, and any officer taking bail on how bail must be set, and just as importantly, what bail must never become. Bail must secure appearance, nothing more. The first rule is the controlling one. Bail and any conditions attached to it must be sufficient to give reasonable assurance that the defendant will appear and comply with the court's orders. Not absolute assurance, reasonable assurance. Bail exists to ensure presence, not to punish absence before it occurs. Bail must never be used as oppression. The law is explicit here. The power to require bail may not be used as an instrument of oppression. Bail may not be set simply to keep a person in jail. If bail is used to punish, to pressure, or to detain by design, it has already violated the law. The nature of the offense matters. The court must consider what the defendant is accused of and how it was allegedly committed. This includes specific attention to whether the offense involves violence or involves violence directed against a peace officer. Severity, risk, and context all matter, but they are factors, not excuses. Ability to make bail must be considered. The court must consider the defendant's ability to make bail. This does not guarantee low bail, but it does require consideration, and proof may be taken on this point. Ignoring ability is not discretion, it is error. Safety of victims, officers, and the community. Bail decisions must consider future safety. That includes the safety of the alleged victim, the safety of law enforcement, and the safety of the community as a whole. Bail balances liberty with protection. Neither is optional. Criminal history and court behavior matter. The court must consider the defendant's criminal history, including prior offenses, acts of family violence, other pending criminal charges, and any history of failure to appear after prior releases on bail. Past behavior is not destiny, but it is relevant. Citizenship status is a consideration. The law requires the court to consider the defendant's citizenship status. This factor speaks to flight risk and jurisdiction, not guilt. It is one consideration among many, not a conclusion by itself. Definition of family violence. When the article refers to family violence, it uses the definition provided by the Family Code. This ensures consistency across bail, prosecution, and protection orders. The essence of the rules for setting the amount of bail. Bail is a measured decision, not a reflex. It must ensure appearance, avoid oppression, consider offense severity, respect ability to pay, protect safety, account for history, and weigh risk carefully. When bail is set this way, it holds up under scrutiny. When it is not, it collapses. Discipline in bail is discipline in justice. Denial of bail for violation of certain court orders or conditions of bond in a family violence case. This provision addresses a narrow but serious circumstance when a person violates a court order or bond condition designed to prevent family violence. Here, the law permits something rare, the denial of bail, but only after strict findings and procedure. What type of conduct triggers this rule? This article applies when a person commits an offence under violation of certain court orders or conditions of bond. That includes violations of protective orders or bond conditions imposed in family violence cases. Not every violation qualifies. The focus is on safety-related conditions. When bail may be denied, family violence bond violations. A person may be taken into custody and denied release on bail if the person's bail has been revoked or forfeited and after a hearing, a judge or magistrate finds by a preponderance of the evidence that the person violated a bond condition related to the safety of the victim or the safety of the community. This denial is temporary, lasting pending trial or further court proceedings. Denial of bail here is not automatic. It must be earned by violation, other violations of court orders. If the person commits a violation offence that is not specifically tied to a family violence bond, bail may still be denied if, after a hearing, the judge or magistrate finds by a preponderance of the evidence that the person committed the offence. Again, the hearing is mandatory, the finding is required, the burden is defined. Special rule for going near a protected location. When the alleged violation involves going to or near a prohibited place, bail may be denied only if the judge or magistrate finds that the person acted with intent to commit or threaten family violence, or commit an act in furtherance of stalking. Proximity alone is not enough. Intent must be shown. Factors the court may consider. In deciding whether to deny bail, the court may consider the specific order or bond condition violated the nature and circumstances of the alleged offence, the relationship and history between the accused and the victim, the accused's criminal history, and any other facts showing whether the accused poses an imminent threat of future family violence. This is a forward-looking safety analysis, not a backward-looking punishment. Timing of the hearing. A person arrested under this provision must be taken before a magistrate without unnecessary delay after reasonable notice to the prosecutor and no later than 48 hours after arrest. At that appearance, the magistrate must conduct the required hearing and make the determination on bail. Procedure is not optional. It is the safeguard. The essence of denial of bail for violation of certain court orders or conditions of bond in a family violence case. This rule exists to protect lives when court orders are ignored. When a person violates safety-based bond conditions in a family violence context, the law allows bail to be denied, but only after a hearing, only with proof, and only to prevent imminent harm. Denial of bail here is not punishment, it is prevention, and it is permitted only when restraint is necessary to protect victims, officers, and the community. Denial of bail for violation of condition of bond, where child alleged victim. This provision exists for one reason. When the alleged victim is a child, the law tightens its grip. This rule applies only to defendants charged with specific felony offenses committed against a child younger than 14 years of age. These offenses include sexual offenses, prohibited sexual conduct, sexual performance by a child, certain trafficking offenses involving sexual conduct, and compelling prostitution. These are among the most serious accusations recognized by law. When a defendant charged under one of these provisions is released on bond, that release is conditional. The conditions are imposed to protect the child and the community. If the defendant violates a condition of bond related to safety, the law allows a severe response. After a hearing, if a judge or magistrate determines by a preponderance of the evidence that the defendant violated a bond condition related to the safety of the child victim or the safety of the community, the defendant may be taken back into custody and denied release on bail pending trial. This denial is not automatic. It requires a hearing, a factual determination, and a finding tied directly to safety. If the magistrate finds that the violation occurred, the magistrate may revoke the bond and order the defendant immediately returned to custody. Once the defendant is returned to custody, any sureties on the bond are released from future liability. This release does not remove responsibility for any forfeitures that occurred before the bond was revoked. Past accountability remains intact. The structure here is deliberate. The law prioritizes child safety while still requiring process, proof, and judicial judgment. The essence of denial of bail for violation of condition of bond where child alleged victim. When a child is the alleged victim of serious felony offenses, bond conditions are not optional. If those conditions are violated, the law permits denial of bail not as punishment, but as prevention. The purpose is immediate protection of the child and the community, achieved through evidence, hearing, and judicial restraint. Here, authority is exercised carefully and decisively. That balance is the law working exactly as intended. If you're ready, send the next article, and I'll continue in this exact format with no deviations. Bail in misdemeanor. Code of Criminal Procedure Article 17.20. This provision explains who may take bail in misdemeanor cases and under what limits. It governs authority at the point of custody, not punishment and not sentencing. In misdemeanor cases, a sheriff, peace officer, or a jailer licensed under state law may take a defendant's bail while the defendant is in custody. This authority exists whether the court is in session or not. The purpose is practical, to allow lawful release without waiting for formal court proceedings when the law permits it. Before taking bail, the officer or jailer is generally required to obtain the defendant's criminal history record information through the statewide telecommunications system maintained by the Department of Public Safety and through the Public Safety Report System. Bail decisions are expected to be informed, not made in the dark. There is a limited exception. When the defendant is charged only with a misdemeanor punishable by fine only, or when the defendant receives a citation instead of being taken into custody, the officer or jailer may make the bail decision without considering the criminal history factor related to past failures to appear or other pending charges. The law recognizes the lower risk associated with these situations. The authority stops where violence begins. If the defendant is charged with, or has previously been convicted of, an offense involving violence, the sheriff, officer, or jailer may not set the amount of bail. In those cases, bail may only be taken in the amount already set by the court. Setting bail becomes a judicial function, not an administrative one. This structure ensures efficiency where risk is low and judicial control where safety is at stake. In essence, misdemeanor, bail may be handled by officers and jailers to allow timely release, but that authority is limited. Criminal history must usually be considered, minor offenses receive streamlined treatment, and any connection to violence shifts control back to the court. The law allows speed, but never at the expense of safety. That balance is deliberate. Bail in felony. Code of Criminal Procedure Article 17.21. This provision governs how bail is handled in felony cases, where liberty is more tightly controlled and judicial oversight is required. When a felony case is pending and the accused is in custody in the same county where the court is in session, the responsibility to set bail belongs to the court. The court determines both the amount of bail, if the offence is bailable, and whether the accused is eligible for release on a personal bond. This decision is judicial, not administrative. Once the court has fixed the amount of bail, the sheriff or another authorized peace officer or a properly licensed jailer may take the bail bond in the amount set by the court. City police are excluded from this authority. After the bail bond is properly taken and approved, the accused must be released from custody. Neither the defendant nor the sureties are required to appear in court at that moment for the release to occur. The law adds an additional safeguard before any release on bail in a felony case. A defendant may not be released until two conditions are met. First, the defendant must have appeared before a magistrate. Second, the magistrate must have considered the public safety report prepared for that defendant. This ensures that release decisions are informed by risk assessment, not made in isolation. Felony bail is therefore structured to move deliberately. The court sets the terms. The magistrate confirms oversight. The officer executes release only after both steps are complete. Felony bail is never casual. The court controls the amount and the form of release, the magistrate ensures public safety has been considered, and officers carry out release only after judicial decisions are complete. Liberty is permitted, but only after structure, review, and responsibility are satisfied. That order is intentional, may take bail in felony. Code of Criminal Procedure, Article 17.22. This provision explains what happens when a felony defendant is in custody and the court is not available to act immediately. When a felony case is pending and the court is not in session in the county where the defendant is being held, the law allows limited action at the custodial level. In that situation, the sheriff, another peace officer, or a properly licensed jailer who has custody of the defendant may take bail. If the court or a magistrate has already set a bail amount, the officer or jailer may take bail only in that amount. If no amount has yet been set, the officer or jailer may set bail in an amount considered reasonable, so long as that amount complies with the rules governing bail. This authority exists to prevent unnecessary detention when the court is unavailable, not to replace judicial judgment. Before taking bail in a felony case under this provision, the officer or jailer must obtain the defendant's criminal history record information. This information is gathered through the statewide system maintained by the Department of Public Safety and through the Public Safety Report System. Bail decisions in felony cases must be informed by background and risk, not made blindly. There is a firm limitation when violence is involved. If the defendant is charged with, or has previously been convicted of, an offense involving violence, the officer or jailer may not set the bail amount. In those cases, the officer or jailer may only take bail in the amount already set by the court. Setting bail remains a judicial function whenever violence is part of the defendant's history. This structure allows flexibility when courts are unavailable, while preserving judicial control where public safety demands it. Accused liberated. Code of Criminal Procedure, Article 17.29. This provision governs what must happen once bail has been properly given. It is direct and it leaves little room for delay. When an accused has given the required bond, whether that bond is taken by a magistrate or by the officer who has the person in custody, the accused must be released immediately. Liberty follows compliance. There is no waiting period built into this rule once the bond requirement is satisfied. The law adds an important safeguard in certain sensitive cases. Before releasing a person arrested for stalking or a person arrested or held without a warrant in the prevention of family violence, the law enforcement agency holding the person must make a reasonable attempt to notify the victim of the imminent release. The victim may also designate another person to receive that notice. A reasonable attempt includes contacting the victim or the designated person at the last known telephone number or address shown in agency records. To support this requirement, the arresting officer should, when possible, collect the victim's address and telephone number at the time of arrest and pass that information to the agency holding the accused. The law also protects agencies and their employees from civil liability related to this notification requirement. Whether notice is successfully given or not, no damages arise from complying with or failing to comply with the notice provision. The obligation is to attempt, not to guarantee contact. The term family violence carries the meaning assigned by the Family Code, ensuring consistency across protective and bail-related provisions. Further detention of certain persons. Code of Criminal Procedure. Article 17.291. This provision creates a narrow, safety-driven exception to immediate release after bond in family violence situations. It exists to prevent continued harm when release itself presents a real and immediate risk. Ordinarily, once bond is posted, release follows. That rule does not apply when a person has been arrested or held without a warrant in the prevention of family violence, and there is probable cause to believe the violence will continue if the person is released immediately. In that circumstance, the head of the arresting or holding agency must continue to detain the person for 4 hours after bond has been posted. This initial delay is automatic once the risk determination is present. It is protective, not punitive. The law allows this detention to be extended, but only with judicial involvement. The total delay may not exceed 48 hours after bond is posted, and any extension beyond the initial 4 hours must be authorized in writing by a magistrate who concludes that the violence would continue if the person were released. If the detention is extended beyond 24 hours, the magistrate must make additional findings. There must be probable cause to believe the person committed the current offense and that, within the 10 years preceding the offense, the person has either been arrested more than once for family violence or arrested for another offense in which a deadly weapon was used or exhibited during the offense or immediate flight. No part of this article authorizes detention beyond 48 hours after bond is posted. When the authorized period ends, release must occur. The definitions applied here are precise and consistent with other provisions. Family violence carries the meaning assigned by the Family Code, and magistrate is defined by statute to ensure proper authority. Magistrate's Order for Emergency Protection. Code of Criminal Procedure, Article 17.292. Now we arrive at one of the most protective tools the law places in a magistrate's hands. An order for emergency protection exists for one reason: to stop harm before it repeats itself. This order is considered at the very first appearance after arrest, and it applies when the arrest involves family violence or certain serious offenses, including trafficking, sexual assault, aggravated sexual assault, and stalking. The law allows the magistrate to act immediately without waiting for a separate request or hearing down the road. The order may be issued in 4 ways: on the magistrate's own motion, at the request of the victim, at the request of a peace officer, or at the request of the prosecutor. In some situations, the magistrate does not have discretion at all. If the arrest involved serious bodily injury or the use or exhibition of a deadly weapon in a family violence case, the order must be issued. Once issued, the order may impose strict and immediate limits on the defendant's conduct. These limits can include prohibiting further acts of violence, cutting off communication with the protected person, ordering the defendant to stay away from specific locations such as homes, workplaces, schools, or childcare facilities, and barring the possession of firearms. The order may also prohibit tracking, monitoring, or following the protected person, whether electronically or physically. The purpose here is not punishment. It is distance. Distance creates safety. The magistrate may also impose additional bond-related conditions, including GPS monitoring, if doing so enhances protection. These conditions are layered intentionally. Each one reduces risk while the case moves forward. The victim does not need to be present for the order to be issued. The responsibility rests with the court, not the victim, to act decisively. Once issued, the order takes effect immediately. The defendant must be served with a copy, either in person or electronically, and a record of that service must be created. Law enforcement agencies are then required to enter the order into statewide systems, so responding officers know it exists and can enforce it without delay. The order carries serious consequences if violated. Violating an emergency protection order can result in jail time, fines, or separate felony charges, depending on the conduct involved. No one, including the protected person, can give permission to ignore or violate the order. While it is active, it controls. The duration of the order depends on the severity of the conduct that led to the arrest. In standard family violence cases, the order remains in effect for a minimum of 61 days and up to 91 days. If serious bodily injury or a deadly weapon was involved, the duration increases to a minimum of 91 days and up to 121 days. The order can be modified later by a court with jurisdiction, but only if modification does not increase risk to the protected person. If the order conflicts with other court orders involving children, strict rules determine which order prevails. In the early stages, the emergency protection order takes priority, unless a later court explicitly supersedes it under the family code. Finally, the magistrate must suspend any license to carry a handgun held by the defendant as part of the order. This is not optional. It is automatic. The essence of magistrate's order for emergency protection. This rule exists to intervene early, decisively, and lawfully when violence is present. It empowers magistrates to create immediate boundaries, enforce distance, and remove tools of harm while a case is still young. The order is not about guilt. It is about prevention, and when used correctly, it protects victims, stabilizes situations, and preserves lives while the justice process continues. General Rights of Crime Victims. Code of Criminal Procedure. Article 56.051. This provision establishes a clear truth that guides the entire criminal justice process. Victims are not spectators. They are participants, protected by law. From the moment an offense enters the system, a victim, the guardian of a victim, or the close relative of a deceased victim is entitled to defined rights that ensure safety, information, dignity, and meaningful involvement. The first obligation is protection. Law enforcement agencies must provide adequate protection from harm or threats of harm that arise because a victim cooperates with the prosecution. Cooperation is never meant to place a victim in greater danger. Bail decisions must account for safety. When bail is set, the magistrate is required to consider the safety of the victim and the victim's family. Bail is not only about securing appearance, it is also about preventing further harm. Information is provided when requested, and it must be timely and reliable. Victims may receive notice of relevant court proceedings, including appellate proceedings, and must be informed if proceedings are cancelled or rescheduled. Appellate courts must notify victims of decisions before those decisions are made public. Victims may also receive explanations of how the criminal justice system works. This includes information about bail, investigative procedures, plea negotiations, restitution, appeals, parole, and whether a defendant has complied with conditions of release. The law recognizes that understanding reduces uncertainty and restores agency. Victims have a voice in sentencing. They may provide information to probation departments conducting presentence investigations, describing how the offense affected them and their family. This input may be given through testimony, written statements, or other lawful means. Access to assistance is guaranteed. Victims are entitled to information about crime victim compensation, including eligibility, covered expenses, and application procedures. Victims of sexual assault are entitled to information regarding payment for forensic medical examinations and related care, and victims may request referrals to social service agencies. Parole is not hidden from victims. Upon request, victims may receive information about parole procedures, participate in the parole process, submit information for consideration before release, and receive notice of parole hearings, release conditions, new offenses committed while on parole, warrants for return, and parole revocations. The courtroom environment must be safe. Victims have the right to a waiting area that is separate or secure from the defendant and the defendant's associates. When separation is not possible, other safeguards must be used to minimize contact before and during proceedings. Property matters. When a victim's property is held as evidence, it must be returned promptly once it is no longer required for that purpose. Employment considerations are recognized. At the victim's request, the prosecutor may notify the victim's employer that cooperation or testimony is required and may cause absence from work. Victim-offender mediation may be requested. When appropriate, mediation coordinated by victim services may be pursued as an alternative means of resolution. Victim impact statements are formally protected. Victims must be informed about their purpose, how to complete them, and how they are used. These statements must be considered before sentencing, before acceptance of plea agreements, and by parole authorities. In cases involving assault, aggravated assault, sexual assault, or family violence, especially where the victim is a child, the court must consider the impact on the victim when a defendant requests a continuance. If asked, the court must state on the record why the request was granted or denied. In capital felony cases, additional protections apply. Victims have the right to be informed about defense-initiated outreach, to decline contact unless consent is given, and to designate a victim service provider to receive communications. Victims also have the right to be present at all public court proceedings related to the offense, subject to judicial approval, and prosecutors and law enforcement agencies are responsible for ensuring these rights are honored and explained when requested. Advocates acting on behalf of victims are authorized to obtain parole-related information so that victims are not required to navigate the system alone. Additional rights of victims of certain sexual, trafficking, or burglary offenses. Code of Criminal Procedure, Article 56.052. This provision recognizes that some crimes leave deeper wounds and longer consequences. For victims of serious sexual offenses, trafficking, and related crimes, The law provides expanded rights focused on transparency, medical care, and meaningful participation in decisions that shape the case. For these victims, access to information is not a courtesy. It is a right. When requested, victims may receive disclosure about evidence collected during the investigation. This includes what evidence exists and whether that evidence is undergoing analysis. If disclosure would interfere with an ongoing investigation or prosecution, the information may be delayed, but the victim must be told when disclosure is expected to occur. Silence is not permitted. Accountability is. Victims may also request notification at key forensic stages. They can be informed when evidence is submitted to a crime laboratory, when biological evidence is sent for comparison against state or federal DNA databases, and when results from those comparisons are available. If results cannot yet be disclosed, the victim must again be told when disclosure is anticipated. Medical and health-related protections are built directly into this article. Victims may request counseling related to AIDS and HIV infection. They are also entitled to testing for HIV, AIDS, and other probable causative agents, along with a forensic medical examination and related continuing medical care during the 30-day period following that examination. These services exist to protect health, preserve evidence, and restore dignity. The law also grants victims a voice in how the case is resolved. When requested, victims may be informed about and confer with the prosecutor regarding major disposition decisions. This includes decisions not to file charges, dismiss charges, use a pre-trial intervention program, or enter into a plea bargain agreement. The prosecutor retains authority, but the victim is no longer excluded from the conversation. To make these rights functional, victims who request notice or information must provide current contact information to both law enforcement and the prosecutor, and must update that information if it changes. Victims may also designate another person or victim service organization to receive notices on their behalf, so long as that designee is not the defendant. For certain victims, especially children and victims of sexual offenses or trafficking, the law goes further by connecting criminal proceedings to protective orders. Victims, parents, or guardians must be informed that a protective order may be requested where it may be filed, and that the prosecutor may file it on their behalf. In many cases, the prosecutor is required to seek a protective order if the defendant is convicted or placed on deferred adjudication. Victims may request that the prosecutor file the protective order application and must be notified when it is filed. If the victim is present at conviction or placement on deferred adjudication, the court itself must provide this information and allow immediate filing when jurisdiction exists. If the victim is not present, the prosecutor must provide that information afterward. The law also recognizes that victims of trafficking-related offenses may themselves have criminal records tied directly to their victimization. In those cases, victims must be informed of their right to petition for an order of non-disclosure of criminal history information, provided the offense was committed solely as a result of being trafficked. The essence of victims' rights in the criminal justice system. Now take a step back and look at these provisions together. When the law speaks about victims' rights, it does so with intention and structure. These rights are not symbolic. They are operational, enforceable, and tested regularly in real cases. At the most fundamental level, victims are entitled to safety. Law enforcement must provide protection from harm or threats that arise because a victim cooperates with the prosecution. Bail decisions must account for the safety of the victim and the victim's family. This is not optional, and it is not secondary. Victims are entitled to information, but only when they ask for it. That distinction matters. Upon request, victims must be kept informed about court proceedings, changes in scheduling, appellate decisions, bail procedures, and whether the defendant is complying with conditions of release. The system does not force information on victims, but it must respond fully when information is requested. Victims have a recognized voice in the process. They may provide input during presentence investigations. They may complete victim impact statements, and those statements must be considered before sentencing, before plea agreements are accepted, and before parole decisions are made. This input does not control outcomes, but it must be heard. The law protects victims' dignity during proceedings. Victims are entitled to safe or separate waiting areas, reasonable efforts to limit contact with the defendant, and prompt return of property once it is no longer needed as evidence. These are practical safeguards, not abstract ideals. Employment concerns are addressed directly. Prosecutors may notify employers, at the victim's request, that cooperation or testimony requires absence from work. Participation in justice should not quietly cost a victim their livelihood. Victims are not excluded from parole decisions. Upon request, they may receive notice of parole hearings, release conditions, violations, new offenses, warrants, and revocations. Participation in parole is structured, deliberate, and ongoing. For victims of sexual offenses, trafficking, and related crimes, the law adds depth where harm is greatest. These victims may receive information about evidence collected, forensic testing, DNA submissions, and results. If disclosure must be delayed to protect an investigation, the victim must still be told when disclosure is expected. Silence is never the answer. Health protections are explicit. Victims may request counseling related to HIV and AIDS, testing for communicable diseases, forensic medical examinations, and continuing medical care following those examinations. These rights exist to protect both health and dignity. Victims of these offenses are also entitled to confer with prosecutors about critical charging and disposition decisions, including declinations, dismissals, diversion programs, and plea agreements. Authority remains with the prosecutor, but exclusion is no longer acceptable. Protective orders are woven directly into this framework. Victims, parents, and guardians must be informed about their right to seek protective orders, where those orders may be filed, and when prosecutors are required to pursue them. In many cases, protective action is mandatory once guilt is established. The law also recognizes that trafficking victims may have criminal records created by coercion. In those cases, victims must be informed of their right to seek non-disclosure of qualifying criminal history that exists solely because of their victimization. Throughout all of this, victims must provide current contact information if they want notice, and they may designate another person or service provider to receive information on their behalf. The system requires cooperation, but it does not demand victims navigate it alone. If there is a single principle to remember for examination or practice, it is this: victims are entitled to safety, information upon request, participation, protection, and dignity at every stage of the criminal process. In cases involving sexual violence, trafficking, or severe personal harm, those rights expand to include medical care, forensic transparency, protective orders, and record protection. This is not sentiment. It is structure. And structure is how justice remembers who was harmed.